Hi. Good evening, everyone. I'd like to call the policy meeting to order, starting with a school board director roll call. Um, let's start from my screen. Let's start with Mr. Epps.
Zachary Epps, President.
Mia Blitzstein present.
Ross Whiting, present.
Schultz present.
Jennifer Lohman, present.
And Robyn Murphy present.
And Mr. Burdell Williams is present. He just stepped away for a moment.
Thank you. All right. May I have approval of the minutes from the November 13th meeting?
So moved. Zachary Epps.
Second, Mia Blitzstein.
Thank you. All in favor, say aye.
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 Seeing no nays, I am turning the meeting over to, I'm assuming everyone's still on the screen. I don't see everybody. Turn the
You're all
meeting,
here.
yes, turn the meeting over to Mr. Yazio and Adrian Tolbert Jackson.
All right. All right, I'll take it for a little while. So
Okay.
for old business, we don't have any old business items. The board might recall we had a discussion back in November regarding graduation requirements and academic standards. I think the board and the committee can expect to see those items potentially back in a few months. I know that Ms. Savage is working on those items in her new role as teaching and learning director and has asked that we put them back on for a future discussion. So nothing to do in terms of old business this evening, but we do have a number of, there's 14 items here for new business. And I think we'll go through most of them pretty quickly, but there are a lot of items. So um, is the committee okay if we dive right in and get started with the new business?
Absolutely.
All right. So first up is policy 218.2. I'll bring that up on the screen here. Policy 218.2 is our student weapons policy. There was a recent change to the state law that requires when certain incidents happen on school premises that relate to, and not just school premises, it could be with extracurricular activities or transportation. But when there's an incident involving weapons, um, the district needs to send out notification to families. And so you will see that under the delegation of responsibility here, there is additional language around the notifications that need to take place. Um, and that's the basis for the revisions in 218.2. The committee had just looked at this policy a little less than 2 years ago. So otherwise, there's not much that's substantively changing. Any questions about this one? I don't see anyone. Oh, Zachary.
Not a question per se, because I know this is a legal requirement for us. But we've already experienced it. So thanks to admin, because I think we've already received a number of notifications throughout the last few months.
Yeah.
And so for me, in the policy, it's very clear, even when like look-alike weapons or, fake toys are brought to school, like there's still going to be a notification and things like this. So I know like safety broadly, there's a lot of things happening toward safety and communicating about safety and a communications plan and things like that. So I do, so I guess this is really as we are implementing this, just being very mindful of, uh, I guess even when we have like these lookalikes, I just don't want these notifications. I don't want it to like create a sense of like lack of safety that might not be there. And so I just in implementation of this, I think this is just another thing that we have to kind of there's a requirement to communicate, but how we communicate, what we communicate, I think is also important to I just also promote the safety that does exist throughout the schools and what we are doing to maintain safety.
I do think that's an important point, and we will wait to see how other districts implement the new law. The law is clear that from a notification standpoint, weapons violations are not only weapons violations as the state defines that term, but also any weapons violation that violates local policy. And so Cheltenham's local policy, which is consistent with almost every other public school district around here, prohibits, duplicate weapons, toy weapons, replicas, all of those things. I suspect that some districts are going to maybe take the position that that's not the state law definition of a weapon. And I'll be curious to see what types of notifications go out. But under a reading of the law, local policy violations on weapons are to trigger these notifications. I know that Mr. Kaufman put together a communication that went out or is going to go out to the community talking about the obligations of the district to make these notifications so parents can begin to expect them. Unfortunately, I guess is the right way to say that. And we were mindful that when we wrote that communication, we specifically indicated that toy weapons and look-alike weapons would also be part of that universe in hopes of expectation setting.
Yeah, I appreciate that. And I'm also reminded of our robust conversation, and Ms. Lohman even brought this up, the case by case discretion that is sometimes available because of the broad sort of sometimes description of what a weapon can be. So yeah, appreciate the intentionality there.
I don't see anybody else with hands. So the next item, I believe, is the weapons policy 356. And the only change here was we added to the delegation of responsibility a note here that indicates that the superintendent or designee will ensure that the required notifications go out. We didn't copy and paste all of the notification requirements again. Instead, we just said that the specific notification requirements are in policy 218.2 and we cross-referenced to 218.2. This way, if in fact the law ever changes and the notification requirements do change, we'll just change them in 218.1 and then the other policies don't need to change with it. And similarly, I think the third item on the agenda is the public attendance in school facilities policy, and that is on there for the exact same reason that I just mentioned. So those first three items all relate to this new notification requirement around weapons violations. So I'll pause there and see if anyone has any questions about any of these three.
Ed, I need to interrupt just for a second. Siobhan needs a link as a panelist. So Keith, can you send her a link, please? Thank you.
Yeah, I'll work on that now.
All right. We can then go to next item on the agenda, which is 4 and 5 go together, 623 and 624. So 623 is the travel reimbursement policy for federal programs, and 624 is the Federal Fiscal Compliance policy. And there are a series of ARs that go along with 624. These policies are entirely compliance-based policies, right? And they are essentially the rules that apply with respect to when you receive federal dollars. These two policies guide how you have to account for the money and the safeguards in place to make sure the money is used properly. So um, the changes that you're seeing in here are based on PSBA's recommended changes based on the monitoring that the federal government has done over the course of the last several years, and then pushed out to states. So there's really not a whole lot of discretion in these policies. And again, they are things that when the federal programs dollars are under audit, the folks doing those audits are looking to make sure these policies are in place and updated. Any questions about 623 or 624?
I guess I just have one question.
Yeah.
What's the frequency with which we have faculty attending like I guess conferences that are funded by federal grants? Or I don't know if you have the answer to that.
It might be a question when Siobhan gets online. I mean,
Okay.
certainly any travel related with Title I dollars.
Oh, okay.
So it's any of your title programs. So
Got it.
if there's professional development or things related to that money, a lot of times these requirements come into play.
Got it. Okay, thanks.
Mr. Schultz has his hand up.
Yeah, I just a clarifying question around, and I recognize we don't have much discretion, but I would like to understand the impact. Um, since this is related to the federal government and funding from the federal government, I know earlier, I guess it was last year, there were more regulations and guidelines related to the the types of programming that federal funds can be used towards and whether organizations and institutions that have equity as part of their purpose in an event can't use federal funds for it. Does this impact, like, is this related to that? I know a lot of universities had to do audits of their subgrants and things along those lines. Are we affected by that?
There's nothing in here. All of these revisions predate, like these recommendations were actually, I believe, recommendations that came out in 2024.
Okay.
So you're not seeing anything in here that's super recent. And there's nothing in here that limits, there's nothing in here that imposes any additional requirements on the district in the event that it receives money. So if
Okay.
the district receives money from the federal government, these policies aren't committing us to do or not do certain things that we were doing or not doing previously.
Thank you.
I think that answers the question.
It does.
Okay. All right. All right. So
Well, now that I'm on, do you want me to answer the previous question around what kinds of programming is available in terms of conferences for us to use for these federal programs?
I think that was the question. Yeah.
That
Sure.
would be great.
Okay, so
And like the frequency. My question was really like how often do we have people who are attending PDs and things, that we're utilizing this policy?
quite often, and we actually have a team in Pittsburgh right now that got snowed in to a federal programs conference. But we do this on a regular basis because there are certain conferences that are sent to us in terms of the information through the Montgomery County Intermediate Unit because they do assist with not just the federal programs programming itself in terms of what we use, but also making sure that people are connected to the types of conferences that can be utilized for federal programming. And federal programs does not include just Title I. We have Title 1, 2, 3, and 4 grant funds, and therefore you see that those grant funds are used for conferences in a variety of ways. So, for example, Title III is for English language learners, and we often see that we have Our ELD teachers will go to conferences together. They might actually attend some offerings through the MCIU that are then paid for through those grants. There are separate Title I requirements that we do have to meet, and at times we do send teams to federal programs conferences. So it's actually it occurs more often than you would think.
Thank you.
Absolutely.
Right. So next would be policy in AR 204, which is our attendance policy. There was a change to the state law. The policy remains unchanged. Policy is short here. The change is in the AR. There were a couple cosmetic changes here, but the substantive change was that when a child is determined to be habitually truant, which is a term that is meaningful in Pennsylvania. So habitually truant means when a student has 6 unexcused absences or more in a particular school year. There are required notifications that the district has to send out periodically to try to help the student improve their attendance. And the new state law requires that after the third unexcused absence in the notice that the school district sends to the family, we need to include a notice that includes consequences if the student becomes habitually truant. And we also need to indicate that a habitually truant student may not transfer to a cyber charter school unless the judge determines that it's in the best interest of the child. So many times, I shouldn't say many times, but it has happened. It happens more often than you think that a student is not coming to school. And the student should be coming to school. And when the parent gets to truancy court or the child gets to truancy court, all of a sudden the family will say, well, we're not going to come to school anymore. We're just going to enroll in a cyber charter school and stay home, right? And the legislature has determined that that is not good policy, that if you have a student that can't get themselves to school, and there might be reasons why they can't get themselves to school, that, retreating to a further into the home, right, to a cyber charter school is not in the best interest of the child unless a judge determines that it is. So we revised our policy to state that the notices will will say these things, and Ms. Keene has already alerted her team to update the notices that will go out to the families. So we are complying with this requirement already. I think that was pretty much it substantively. Any questions about that? Mr. Epps.
Yeah, I do have a question. There's a lot of references to the community-based improvement or like attendance improvement plan or something.
Yep.
Instead of going the route of like filing a citation and things like that. So it might be inherent there, but I just wonder, is it worth raising to the level of policy that the district will or intends to exhaust all of those levers instead of pursuing like the citation route? Or just curious.
I think practically speaking, a lot of these school-based and community-based attendance improvement programs, they're slow. Some of them are through the IU. They're full. Um, Unfortunately, they're not as readily available as we probably wish they were. And frequently, cases that involve large numbers of absences end up going through the citation route. Now, I will say it's infrequent that a court actually imposes punitive penalties on a child or a family for attendance. Usually what happens, and we're fortunate in Cheltenham to have, local judges that hear these cases that are student-centered. When the school district goes into a truancy hearing before the judge will talk to the student, talk to the family about the importance of school, will usually continue the hearing and say, I'm going to give you another chance. Sometimes they'll continue it multiple times. We're going to come back in 30 days. And, if you don't have any more unexcused absences in the next 4 weeks, we'll clear out these citations. Sometimes there are times when the court can, um, um, you know, it's a partnership between the court, the parent, and the student. And so sometimes the parent needs the court to get involved, right? And needs the court to be to set a deadline and to talk to the kids. It actually helps the way the court system works with truancy. It's less punitive and more about trying to get all the parties that need to be on the same page to get a child to school to make sure that they're on the same page. It's actually very rare that you see a student actually get cited and get fined for truancy. And I think that's because the courts recognize you go through that whole process and someone gets ordered to pay a fine of $250 or $350, but the problem is still there, right? The problem is still there the next day. So again, we are fortunate locally that our judges that hear these cases are student-centered.
No, I appreciate that. That's encouraging. So not to digress into the justice system and the other stories we hear about it, but especially to this, that's encouraging to hear because preaching to the choir, but truancy we know is often a symptom of other root causes. And so I appreciate that the system is working as it should in this case. Yeah.
Yep. All right, next up we have number 7, AR 610.1. So this was an AR, so policy 610.1 got repealed a number of years ago, but the AR was never repealed. So this is an AR that exists without a policy. I do think that it may make sense. This policy in AR used to delegate to the superintendent and the business office the ability to move forward with contracts that were below the bid threshold, as long as those contracts were budgeted for and there were sufficient funds in the budget prior to seeking board approval. And so what would end up happening is the board would still see these contracts, but they would show up in the list of bills, right? And so the threshold was $18,000. That was the bid threshold many, many years ago, probably back in 2014 when this was last looked at. If the board still wanted to see um, that that exception to the board approving every contract in advance, policy 610 would be the place to put it. It would be in the procurement policy. And policy 610 is already going to be on our next agenda for a routine update because the bidding thresholds changed on January 1st. So we'll be bringing 610 back for an update. I was going to speak with Josh to see if he had a recommendation to the board around what to do. With respect to this language that's in AR 610.1. But in the meantime, we just wanted to get the AR cleared off the books because it was lingering out there with no policy authority behind it. Any questions about that? All right. Let's see what we've got next. Policy 619, District Audit. This is just a routine review policy. Don't think a lot has changed here. No. Put the legal citations in their proper place down here. These December 31st deadlines, we took them out and we instead just indicated that we would submit forms by the required deadline because the state regularly grants extensions to some of these deadlines. And so as long as we're operating within the timelines that are required by the state, we should be good there. And then um, we updated Josh's title throughout, but those were really the only changes to 619. Any questions? I don't see any. All right. We've got 228, which is our student government policy. I recall making a few changes in 228 here. Let's take a look. We clarified that the student council is in terms of when we think of our student council, we're talking about the high school. We added this sentence here that memorialized existing policy or existing practice that at regular board meetings, the board has an opportunity on the agenda for a student council report to hear from one or more student council representatives. And other than that, this sentence that was deleted here was just moved down to the guidelines section. So that was really the only change. This was just a routine review for our student government policy. Keep going here. Policy 224, care of school property. I believe that was also routine review. Some of this language that was previously in the delegation of responsibility actually existed down here in the guidelines. So we were able to tighten that up a little bit. Otherwise, not much else. We added a purpose since usually our policies start with a purpose. Otherwise, there was not really anything new with this one either. I see Charles has his hand up.
Yeah, thanks, Ed. So just at the bottom of this policy is the line related to reporting vandalism events. And so just the curiosity if they're either on part of administration or if we are familiar with any threshold, like value amounts or um, severity of vandalism, like as a way of like navigating when to communicate with the board, like just thinking, if you know, something very minor happens, I don't know if that would necessarily warrant the, sharing to the board, but that's just me as one board member, just out of curiosity, wanting to understand what that might look like for us.
I can talk with Josh about how his office tracks this. Um, we took out, I purposely took out the word periodically up here and put it on as needed
Mhm.
because in my mind, the board would be made notified if there was a significant incident of vandalism, right? That either resulted in a significant expenditure, or if, someone spray painted the whole side of one of your school buildings with something inappropriate, right? Like you would hear about a big incident, but periodically seems to suggest that it's whether it's periodically every 3 months or periodically every 6 months, that at some point in time you should expect to see a report. Whereas I think as needed just means it may be 3 times a year, it may be no times a year. It just depends on what happens. But if you're looking for a recommendation there, when I talk to Josh about the 610 policy, we can also bring back a recommendation on 224.
Yeah, and I'll just kind of like lean into like why I'm asking, right? Because there are, right, on behalf of administration, school administrators, and everybody who's doing the work, right? There are some incidents that are, managed on an individual level, right? The student did something, they, broke a pencil or ripped a page out of a book from the library, right? And like I thinking similarly to what Mr. Epps I think was leaning into a little bit earlier, right? It strikes me about making that like a board activity as if it is how heinous the act is is like sort of being disregarded in a way because um I would want the child and whatever they may be experiencing that may have led it or any precursory actions like I would want that to I would expect something like maybe for that to be considered in a way as opposed to maybe blanketing all, but that's just my perspective. Not wanting to put that on a child in this way. I mean, we won't see them by name or anything, but I'm just thinking about the magnitude by which something could be viewed when it is brought to board level.
Yep. Looks like Dan's got his hand up too.
Yes. So I had a question around, I see we have an administrative regulation. It's not on this agenda, but there is a paired AR. The policy is being updated to say may develop an administrative regulation instead of shall. I was curious what the rationale for not requiring an administrative regulation to get into more detail when we already have one. So, um,
I think, Mr. Schultz, that may have been an oversight on my part. I don't
okay,
think I knew that that was there. So I actually think we can change that to back to shall if it's there.
okay,
Yeah,
great.
that's a good point.
And then I had thoughts around the AR, but maybe that's for a future meeting rather than tonight.
Yeah, so I think that's not actually on the agenda only because um I didn't see it in the
Sure.
for whatever reason. So this will have to go, the policy will go through two readings. So
Hmm.
we can bring the AR back and still get the AR and the policy done at the same time. So I'll make a
Sounds
note to make
great.
sure that the AR goes on the next agenda. Sorry about that.
Oh, no problem. Thank you.
Thanks for catching that.
So, and I think we did include the AR, but we
Did
could have.
we? Is it in draft? I don't
It
see it
might,
in
it's
draft.
not in draft, but I think I referenced it in on the
Oh,
agenda.
on the agenda? Well, if it's
Yeah.
on the agenda, then we can certainly take a look at it. And
I'm also, for what it's worth, I am completely comfortable personally waiting until the next policy meeting. I don't want to.
I think I mean I think it would be helpful if you have feedback that might
Sure.
guide further revisions.
My
Let's
thoughts
do it.
are around the AR were really around from an equity lens of striking a balance of course, we want to set expectations about responsibility. Um, on the other side of things, we're talking about dollars and cents that will impact different families at different levels if mistakes are made or if damage is done. And so I wonder if there is a way for us to um, accomplish both goals of, and I'm thinking, for example, of our Cheltenham Library System has abolished late fees, for instance. We don't have late fees, but the equivalent for us might be, uh, think if it's not exceeding a certain dollar amount, allowing a building principal to sort of give grace, like a student doesn't lost a library book, it costs $10, rather than not letting them participate in the end of year, et cetera, et cetera. They can still go and that again, I'm not trying to get actually
Yeah,
in the
no,
weeds. I'm
it's
just saying that's the
helpful.
spirit of the question I have around this AR. Is there a way for us to have enforcement of responsibility while also, kids make mistakes and sometimes can't necessarily, as a family, afford repairing all those mistakes.
And
That's
is the thought that a lost book or inadvertent damage is different than vandalism?
that is exactly yes, and I
Okay.
recognize that's hard to capture in policy language, but
Mhm.
that is kind of what I'm getting at.
Okay. All right. We'll
Yep.
keep that in mind as we
Yeah.
move.
And then the other thought I had was, I know Dr. Scriven, you've talked about we want to be more consistent across our buildings. And in the AR, I do see room for some inconsistency, particularly around the prior to being issued district-owned property. Parents and guardians may be required to sign a return acknowledgement responsibility form at the discretion of the building principal. So it may be that if we want to just be consistent one way or the other, just throwing it out there for consideration. It also may be that this language is exactly what it ought to be. Um, so that was it.
And we'll take a look. At one point in time, this policy was relevant before we collapsed the district issued Chromebooks into the use of technology policy. So the Chromebook policy used to be district issued Chromebook policy used to be its own standalone policy, and sort of the consequences for not um, doing what you were supposed to with those devices was handled through the 224 process. Now there is policy language around what happens when you don't return the Chromebook. All of that is in the acceptable use of technology. So we'll take a look at this. This form may not even be something that's being used anymore, or if it is, we'll update it. And I think I agree. It should be one or the other.
Thank you.
It's a good point. All right, I don't see anybody else with their hand up, so we will keep going here. Policy 205 is our postgraduate students policy. I don't think there were any changes there. This was just a routine review. This policy essentially just states that once students age out of the system, the board is not responsible and doesn't do anything in terms of adult education, like post 21. So nothing had changed in this policy. Any questions there? If not, we'll keep moving. Next would be, so 706 and 706.1 are the property records and disposal of district-owned property. Let's start with 706. You'll note most of these are the policies that were revised around 2018, 2019, 2020. They're coming up just through the normal process through their review. Really no changes to this policy. Added a cross-reference to policy 622. Changed Josh's title to Director of Business Services. Go on to 706.1. This is the policy on disposal of district-owned property. Again, nothing really new in this policy either. One of the things that you'll likely see on the next agenda, so we're looking at our property records policies this month, which there's not really anything to those policies. We've started to look at the student records policy, which is a much bigger policy. I think that AR is like 15 pages long. It's likely that's coming up for its routine review, and you'll likely see that on the next agenda. Go ahead, Dan.
This is a very pedantic question, but when we say the superintendent and director of business services shall first determine whether such property can be used elsewhere in the district, for instance, um, what does that mean? And in terms of like, can one of them independently make a determination? Does it have to be both of them
It
in
really could just
tandem?
be it really could just be superintendent or designate. The thought there was sometimes what comes under this uh, policy is like when you have curricular materials or books that you might not be using anymore. Your business manager may not be the person that actually knows whether they could be used in a different building. That might be more of an ed side of the building, an Office of Education side decision. So um, I think it should actually just say superintendent or designee. That's the language we usually use. So we can, if the board's okay with that, committee's okay with that, we'll just update that. That's our standard practice, is to say super or designee.
Thanks.
Any other questions on this one? And then, as promised, the policy 206 is on the agenda tonight, which is our student records policy, but it's a very, very short policy. It doesn't really say a whole lot. Um, there are no changes to it, but if we were to go into the active manual here and look at 206, the AR, it's a very lengthy 16-page document here, which we will convert to a Word document and make this easier to read. There's all sorts of attachments here that should go in separate documents. You're going to see all of that next month, but we wanted to get the policy started since that has to go through 2 readings, and that policy did not need any updates. So I think in terms of as we think about the next meeting, which I think is in March, you're likely to see policy 610 on procurement, the policy 206 on student records, and then if there are any other policies, if the academic standards and graduation requirements policies are ready for discussion at that time, they can go on the agenda or they can go on the next one. And then we'll continue cycling through sort of the routine review. We're still in really, really good shape with the policy manual. Every time we get together, we're still getting to items that are just routine review, which means that we're keeping up with all the changes in law, and yet we're still continuing on our cyclical review. So I think that's something that, the board should feel good about as a team. I think that's all I've got. Unless
If no one has any questions about the current policies, there is an attendee, Judy Heath, who would like to address the committee. Keith, if you can allow her to speak.
Thank you. Thank you. Can you hear me?
Yes, and Ms. Heath, if you would please tell us where you reside in the township, that would be great.
Sure. Sure. I am on Oak Road in Glenside. Both of my boys graduated from Cheltenham High School. I want to say 2010 and 2013. My older one is now a sergeant in the Cheltenham Police Department. I'm also here with 2 other people, David Flax and Pam Albright. We're part of a grassroots organization. We're Cheltenham residents. We put together a group called Cheltenham Immigration Response, and we assisted the Cheltenham commissioners in creating the resolution that protects our immigrants, whether they're working or living in our township. So we worked on that. We have been looking at the district letter that went out to the parents back in February 2025, immigrant rights in Cheltenham School District and the frequently asked questions. And so we just had some thoughts about it, some concerns about it. We were so pleased to see that a letter did go out to all of our families. But given the increased fear of our immigrant communities, everything that's happening across the country, we're just wondering if it's time to update the policy, use some stronger language, be more specific about protections, perhaps be put in language that the common person would understand. Is it going out in the languages of our community members? We also wonder if students are aware of it? Is there a protocol? If I should show up, has administrators been trained? So we just have some questions, and we just feel that, once again, so thankful that the letter went out, but is it time to sort of revisit it, revamp it, and really make our community feel that they're safe and secure in our schools?
So, good evening. This is Dr. Scriven. I'm
Hi.
not sure if this is the forum um, to address that. I'm more than willing to meet with you guys and schedule time for us to sit down and have a deeper dialogue um, because we don't have any official policy. We have protocols that we have established. So, Mr. Diazio, I'm going to kind of defer to you in terms of the best way to move forward to potentially address the or get clarity on the specific asks.
I think it would be helpful if the group has some specific recommendations. Dr. Scriven, I'm even happy to participate in a meeting. I'd be curious to hear what the suggestions are. And we can then kind of triage, is it that our prior guidelines should be relooked at? Is there an update to anything that needs to take place? Is there something new that needs to be created? But I think I'd be happy to work with the group as they noted. I'm familiar with their work through the advocacy they did on the township end of things, and we could certainly find some time to sit down and have a discussion. I think that would be a good use of time.
I think that's amazing. We really appreciate that. So what would be the best way for us to reach out? Do you want our recommendations in writing? It'll probably take us a week or two to meet again as a group to put something together in writing to present to you. What would be the best way to proceed?
Yes, if you could actually present something formally in writing, and you can direct it right to me at bscriven@cheltenham.org. And even while you're working on that, we can get a meeting scheduled in the immediate future while you're putting that documentation together.
That's great. Thank you so much. And I'm assuming that we should just contact your secretary to get that on the.
Yeah, if you just copy her, that's G Hatcher at cheltenham.org.
Okay, great. Thank you.
Yes, ma'am.
We really appreciate your time and allowing us to participate and to ask our questions. So thank you so much. And once again, thank you so much for protecting students. That's first of all of utmost importance.
Yes, ma'am. Thank you.
Okay, thank you.
Thank
I
you.
don't see any hands raised or additional Q&As at this time, Ms. Murphy.
Thank you. So seeing none, I'd like to ask for a motion to.
I'll set the before I set the motion. I think we
After
probably,
Mr.
if it's
Epps is
not,
done.
yeah, no, I'll set the motion. But if it's not too exhaustive, I feel like we a couple of times we heard, we've reviewed 90% of our policies since this, that, and it gave us a little boost of energy and some motivation. So if it's not too exhaustive, it would be nice to know at the next milestone of policy review or wherever we are.
I update that chart every time the board meets, so it's very easy to pull some statistics together. I'll gladly bring them to the next meeting.
Nice, nice. As one board member, as everyone says, and
I'll
I
second the
move
motion.
a nice move to adjourn.
Oh,
Nice.
All in favor, say aye.
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 The meeting is adjourned. Thank you, everyone, for your presence this evening.